Welcome to our commercial real estate series, Behind the Building, giving the audience a behind the scenes look at different aspects of commercial real estate, featuring industry leaders who we work with every day to make it all happen. With me today is Lindsey Abboushi, attorney with Brownlee, Whitlow, and Prate. Lindsey's principal areas of practice are in commercial real estate contracts, commercial lease drafting, commercial collections, and landlord collections. Welcome, Lindsey.
Thank you so much for having me, Emily, and thank you for that wonderful introduction.
Certainly.
I just want to start off by saying, as an attorney, I have to start off with a disclosure. The following content is for informational purposes only and does not constitute legal advice. Listening does not create an attorney-client relationship, and if you need specific guidance, please consult a legal professional. Again, a lot of this is my opinions and interpretations of things that I specifically have gone through in this industry.
Great. Love it. So, yeah, let's just dive right in after all that great disclosure. And I think that folks will be able to glean a lot of good nuggets that are just informational only, not advisory. So, when you start working with a client related to a purchase agreement, what are the first pieces of advice that you start offering? What are you looking at in a purchase agreement? What are some of those provisions that are most critical to an agreement?
Okay. The first things that I like to tell clients to look at is timing and money flow, because that's where leverage lives and dies. Obviously, let's start at the beginning, the due diligence period. Is it long enough to actually perform the inspections, title, survey, environmental, lender review, and maybe some zoning confirmation? Are exceptions and extensions built in? If so, how much do they cost and how long do they give? And then the deposit. When does the deposit go hard? The moment the buyer's money becomes non-refundable. So we need to understand when that triggers, what happens, what conditions lead to it, and where the money goes. Do these deposits go towards the purchase price or certain extensions in addition to the purchase price? And what happens to all of these deposits if there's a breach? And then, of course, closing conditions. Is closing tied to lender approval, title clearance, delivery of key documents, or even in some cases, all of the above? So basically, timing equals control. If the buyer or seller loses control of the timeline, you can lose your leverage. So that's kind of my advice on that one.
Wow, that's a lot of details, and that 100% alludes to why folks need you, in the process of representation for their purchase agreement to make sure that they're, protected through all the different milestones of the transaction.
Yeah,
So
I would
for
agree.
first, pardon?
I thought I would definitely agree. I mean, as we go on, I just think that a great piece of advice is to just get your attorney and get your attorney early for the transaction, because this is something that we do. This is what we live and breathe in this industry. And it's like I have all of these mental checklists that maybe sometimes someone doesn't think of. And it's more collaborative too. So,
Hmm. Yeah.
yeah.
So a lot of folks have only participated in residential transactions, and they're not really familiar with what it looks like and all the things that you just talked about that are related to commercial. What are some of the biggest differences so that folks can move from a residential mindset to, okay, we're in the commercial space and this is what it means?
This is actually one of my favorite questions because it's a huge difference. For example, commercial contracts are heavily negotiated. Every clause can be negotiated. Every word carries some sort of risk, and every deal in their way kind of tells their own story. So each agreement, in my opinion, should be custom built, as again, every line matters. You can't just assume that standard means fair in commercial, as each transaction is different. And then I think like another big one is disclosure versus diligence. In residential, you have seller disclosures and usually a trusted home inspector who has your back. But in commercial, the burden shifts to the buyer. The buyer should, in my opinion, do a long list of due diligence items to protect their investment. For example, title, environmental, zoning, leasing. Because again, in commercial, sellers typically make very few warranties and they may only survive for a short period of time after closing. And of course, again, timing. Commercial deals move to the rhythm of business, not motion. And as my paralegal likes to remind me on those crazy closing days, that there is not a family waiting outside with a moving truck. So in commercial, closings can happen early, late, multiple extensions, or multiple issues. So I would just, again, reiterate that commercial is all about customization, diligence, and flexibility. And it's less about moving in and more about moving wisely.
Right. Checking off all the boxes
Yes.
and not the rush
Yeah.
involved behind it. Yeah, yeah. So let's talk about contingencies that you often see in the purchase agreements. What are some of the most critical contingencies that you see or negotiate in the commercial purchase agreements?
I mean, I would say the biggest one is due diligence. That's the buyer's window to inspect the property and walk away scot-free, usually, if something's not right. Um, Also, it protects the buyer's deposit while giving the seller a clear cutoff date when the deal becomes firm. There's also some zoning contingencies and land use. If they buy a property, they want to change the use, let's make sure that they can actually do that. Environmental, testing, for example, let's say if contamination appears, what are the remedies? Do you terminate? Do you remediate? So liability shifts there. And of course, financing, if we can get it in there. Sometimes lenders do change mid-transaction, and maybe some survey and title contingencies to ensure clean marketable title, because isn't that really the goal here? So,
Exactly.
yeah, just kind of figuring out the balancing act of what to protect your client with while having a clear path to close, in my opinion.
Let's talk about the closing mechanics that relate to the timing throughout the escrow, the title, post-closing obligations. What are some of the hidden items in commercial closings that can delay or derail a transaction?
Yes, the part where deals quietly fall apart and give me gray hairs. Most commercial closings aren't lost because of big disputes. They're lost because of missing details and communication issues. So let's talk about some of those issues. If there's a lender, the lender's the one who drives the bus. They'll usually need a laundry list of corporate documents such as formation, good standing certificates, opinion letters, insurance, estoppels, and resolutions. And sometimes there are multiple entities, which means even more moving parts and paperwork. So if these documents aren't gathered early, funding stops. The lender clearly needs proper verification to know that your entity has authority and is in good standing to determine their risk. I would say then title and escrow. Alta endorsements to shape policy, payoffs, and lien releases. These are all, again, coordination and communication. Let's say prior lenders or municipalities move slowly, then your closing's going to move slowly too. And then post-closing obligations. Things like asserting warranties, transferring permits, or updating utilities. I know they sound minor, but when they're missed, they can cause real operational problems and a headache for all parties included. But again, out of everything, I would say the most important thing in closing is communication. Commercial closings involve basically a small army. So they're not just buyers, sellers, and attorneys and lenders. You have other parties like surveyors, brokers, and title companies that are also involved. So if one drops the ball, it typically affects everyone. So prepare for a lengthy email thread to keep everyone on track. And I would say that the best closing attorneys act more as project managers long before closing day. And we regularly annoy everyone with status updates to ensure that the deal stays on track. So pester away.
Yeah, project management. I feel like that's part of our role as a broker too. And you are seeing so much of this transaction play out around and within your army to get this done. So 100%, it is about project managing and communication. And if something is kind of going awry or delaying, that proactive communication can certainly help smooth things over and create clarity on how do you move forward. And just, it's just goodwill. It creates goodwill if you're constantly communicating and having a positive, you know, workflow. So with commercial properties, environmental contamination, zoning issues, those are big parts of the transaction. They can be. So, how do you incorporate those items into your contracts, and what kind of protections does it involve for the buyers or sellers?
It's a great question. Again, environmental and land issues can completely change the risk profile of a deal. So when I'm negotiating, I like to recommend a due diligence period long enough to complete environmental testing, not just phase one, but phase two if needed. For those of you that are unaware of the difference, phase one typically is more non-intrusive to determine if contamination is likely. And phase two is a bit more invasive to determine if contamination is actually present and then to what extent. So when drafting for the buyer, I would recommend that the seller disclose any environmental testing or reports that they've ever received, including those that they may have received when they purchased the property. But again, on the flip side, if I was representing the seller, I'd obviously have different terms and try and keep all of that out for liability purposes. So regardless, if contamination is found, I think the contract should clearly define who bears the cost, whether the buyer can terminate or require remediation. And then you'll also want to build in an environmental contingency so that closing is conditioned on satisfactory results. Depending on the situation, it may even make sense to include post-closing escrow holdbacks. So that's another part. And then for land use, so diligence matters again. So you need to verify zoning, flood plan status, stormwater management, and site approvals. The buyer should confirm that the property can actually be used for its intended purpose before their deposit goes hard. So environmental issues don't just delay closings, in my opinion. They can transform a good investment into a long-term liability. So a smart contract anticipates the risk up front, which is another reason to have an attorney review the PSA before you sign it.
Exactly. Yeah. So, in your experience, what are some of the bigger red flags that you might see if someone comes to you with a purchase agreement in hand? What do you feel like you need to dig deeper into when you see some of these terms or, provisions?
Well, red flags are everywhere. So it's important to know what to look for. And for me, I love threes. So born on a three, love threes. So in my mind, I have a three-tiered checklist. So number one, I would say, is short due diligence timelines with no extensions. So if a commercial contract gives you 15, let's say 20 days to complete full due diligence and find financing, for me, that feels more like a trap than a transaction. Again, every deal is different, but that just kind of is a radar in my head. Number two, my biggest pet peeve is standard forms. So there's no such thing as a standard form in commercial real estate, in my opinion. So these forms are missing critical provisions that pertain to the type of property you're purchasing. So, for example, would you want a multifamily community purchase and sale agreement to look the same as you would for, let's say, a gas station? I wouldn't. But again, I think that, standard forms are just kind of not where you want to be in this field. So number three, I would say little to no representation of warranties. So basically, the seller isn't confirming anything about title, environmental, or any pending litigation, which could potentially shift the burden to the buyer. So missing language about closing conditions also is a red flag. And then deposits going hard immediately, another red flag for me. So when you kind of like see these patterns, I think the most important thing you can do is to just kind of take a beat and slow down because speed in commercial real estate usually benefits only one party, and it's usually not your client. So that's
Right.
that's how I feel.
Yeah, yeah. And you made a really good point that we as broker practitioners, we do have the ability to use the standard bar forms that North Carolina has offered to us. And there are sometimes that it's appropriate to use that with it not being a complicated transaction, small, dollar amount, things like that that are just really cut and dry. And so it is important to know when it is appropriate to turn that over to our trusted attorneys like yourself to make sure that our clients are represented well. So that's just definitely a plug for lots of transactions need to be tailor made, and that's most certainly where you come in. So as we round out this awesome interview, just for viewers who are thinking about buying their very first commercial investment property, if you had to give them one piece of advice, one nugget,
Only
what
one?
would it be?
I mean, I would say that's an easy one because anyone who's talked to me on this topic knows. My biggest piece of advice is hire an attorney early. I like to be brought on before the LOI is signed, because by the time the PSA is drafted, most of the key terms are already set, and then trying to renegotiate missing provisions later almost always costs a lot more time and money than it would have upfront. So I actually have a recent example I can share. I had a client come to me after signing a PSA, and the PSA did not have any extension rights. It just wasn't in there at all. And this client did not have a lender. They were purchasing this property. So they finally secured a lender, and the lender had a checklist, as I mentioned above. They typically do lots of things they require, and one of them was an updated survey. So at this time, the surveyors were super backlogged, and this lead time was about 30 days. And not knocking on any surveyors, but that is just a suggested 30 days. So that can mean a little longer. So when deadlines matter, I like to add more time in for that. So in this in this situation, we had less than a week before the due diligence deposit went hard and no survey. So I was luckily able to negotiate a last minute limited scope survey exception, which allowed my client to object to items specifically related to the survey. And it did cost them a pretty penny because, again, we didn't have leverage at that time, and the seller knew that. But had it been, had I seen an LOI that didn't have any exceptions or extensions included, again, red flag going off in my head. So I just think that you shouldn't wait until a PSA is already signed before consulting with an attorney, because the sooner we're involved, the less money, in my opinion, you'll be spending solving potential problems later. So it's not just about buying real estate here, it's also allocating risk. And each transaction, there's obviously risk involved. It's just a matter of how much are you willing to gamble with.
Right.
And your investors, how much are they willing to gamble with? So,
Yeah.
so, yeah.
Yeah, I think just being proactive, starting early is very wise. That way that you can just start on a good trajectory that will help enable a successful close at the end, which is what both parties want in the end. So, yeah. Well, thank you, Lindsey, for being here with me today. Appreciate you being a part of this Behind the Building series. And I encourage the viewers to reach out to me, as I want to be your resource for all things commercial real estate. I can help connect you with Lindsey and other professionals you need to ensure you're well represented with your commercial real estate property. Thank you for joining us, and be sure to keep an eye out for future Behind the Building interviews with other awesome industry leaders just like Lindsey.